Welcome to today's ArbTech panel. My name is David Earnest. I'm a co-founder and part of the moderating team at ArbTech. I'm also a partner with the law firm of McCarthy. For those of you not familiar with ArbTech, we are an online community dedicated to fostering dialogue on tech, dispute resolution, and the future of law. You can find out more about the organization on our website at arbtech.io. Very much in alignment with ArbTech's mission statement, I am very delighted to moderate today's panel, which is entitled Emerging Technologies in Dispute Avoidance and Adjudication. First, we have the pleasure of speaking with Professor Mimi Zhou about emerging technologies in the field of dispute avoidance, including how to identify and mitigate against disputes. Professor Mimi Zhou is the co-founder of Deriskly, a pioneering AI company that is helping enterprises unlock compliance and customer insights to prevent and mitigate risks of disputes. Mimi is also an award-winning expert in digital, commercial, and private law. She has nearly 2 decades of experience as a dual qualified lawyer, deep tech innovator and entrepreneur, and senior advisor and board member to governments, businesses, and international organizations. She's also a full-time and visiting professor at world-leading universities, and she founded the first legal tech innovation lab at the University of Oxford and has legal degrees from Oxford, including a doctorate. Second part of our panel today, we're going to be speaking with Robert Bradshaw on emerging technologies in dispute adjudication, discussing a host of rapidly evolving tech that legal counsel are today and will tomorrow deploy in the hearing room and as part of dispute adjudication. Rob is counsel at the law firm of LALIVE in London, where he practices international commercial and investment arbitration. He also advises clients in a range of industries, including the energy, mining, media and telecommunications, IT, and healthcare sectors. Alongside his legal practice, Robert has written extensively on topics including evidence gathering, the reliability of witness testimony, and the use of lie detectors in arbitration, a subject which we're going to touch on in a little bit. His articles have been published in the Journal of International Arbitration, the ASA Bulletin, Arbitration International, and Kluwer Arbitration's Tech Toolbox. Finally, he is currently the UK co-chair for the Young ITA, the under 40s branch of the Institute for Transnational Arbitration. On behalf of the ArbTech moderating team, we're very grateful for Mimi and Rob being with us today and taking the time to share all of their insights and experience. Our few housekeeping points. This is slated for about a 40 to 45 minute panel with a 10 to 15 minute Q&A at the end. Please save your questions. We would like a engaged audience, but find that saving questions until the end is a bit more conducive to a discussion with the panel members. Of course, feel free to put your questions into the chat box so we can keep them and be prepared for them at the end of the panel. So without much further ado, let's talk about emerging technologies in dispute avoidance with Mimi. Mimi, thanks for joining us.
Thank you, David. Hi, everyone.
So I'll let you kick off, but I guess my first question to you is, what do we mean by dispute avoidance or dispute prevention?
Yeah, a great question, David. I think we often talk about dispute resolution, or in the case of the arbitration and mediation community, alternative forms of dispute resolution. I just think it's really important to think about from the end user's perspective. So that client of yours could be a multi-billion-dollar company, could be a startup. The best position to start with is actually to prevent the dispute from arising. And so I got into looking at dispute prevention a few years ago, and that was the legal tech lab that I created in Oxford. This is a project that's been very, for me, formerly as a disputes lawyer, something that I saw huge potential for those of us interested in legal tech. For me, dispute prevention ultimately involves implementing measures, tools to de-escalate potential disputes before they arise, before these potential disputes solidify into any hardened positions or turn into formal claims. So often when we talk about mediation arbitration, unfortunately, we're already at the stage of disputes. And so dispute prevention is really about planning, monitoring, and having early intervention to stabilize relationships between parties when those issues first arise, in order to prevent conflicts from escalating. So a lot of dispute prevention, from my point of view, is to do with that proactive monitoring and detecting of early warning signs and issue spotting. And of course, dispute prevention has a lot of advantages over, well, basically dispute resolution, in the sense of obviously preventing a range of direct and indirect costs and time for all parties involved. So that, I think that's what we need to focus on in terms of when we talk about dispute prevention. It is really about a set of tools and measures that any end user of legal services can deploy to prevent, to de-escalate potential disputes before they arise.
I mean, any client of mine probably would be very, very interested in that, because nobody likes to get into a dispute, and we spend a lot of time talking about how to get out of the dispute. But if you can mitigate getting there in the first place, that's a win into itself. But I think one of the issues you've always faced is, how do you know when a dispute's coming? How do you identify a dispute? And by the time you identify it, it's already there. So is tech going to change that?
Yeah, absolutely. I think this is why we're talking about dispute prevention now. I think where we're going with the developments in AI, predictive analytics, a lot of solutions, tech solutions, have become available in the market for businesses, those clients of yours, to leverage both historical data, but also vast amounts of third-party data, along with internal data, leveraging statistical modeling, AI, machine learning algorithms to forecast future trends and events, analyzing all of this data, predictive analytics driven by AI. I mean, some people have been talking about assessing the likelihood of future disputes in particular scenarios. So it's not just about using predictive analytics to maybe forecast whether this particular class action is going to be successful or not. Actually, if we're talking about dispute prevention, we're really talking about using these new tech tools at the very early stage, when parties are even negotiating a particular transaction, looking at data, using these analytics tools driven by machine learning, AI, to see whether one can develop negotiating strategies that are more likely to result in the most optimal outcomes for both parties. Of course, as a starting point, optimal outcomes from negotiations would lay a good foundation to minimize the risks of disputes. So just a practical use case, for example, in real estate, I think this is a sector where there are lots of different scenarios around disputes over, say, property ownership or zoning regulations. And basically, you can analyze both past disputes data, but also external data that takes into account property size, location, use, a lot of the different types of zoning regulations. This big data and analytics, along with, driven by machine learning, businesses can really then identify potential issues and take those preemptive measures, those dispute prevention measures, before entering into a particular transaction, just to, again, to minimize the risk. In other areas like product liability disputes, again, this could be looking at mass quantities of data on customer complaints, customer feedback, product recalls, and actually using these tools to predict potential dispute risks, and for businesses, of course, to take proactive measures early on to address them, improve product design, quality control measures. So these are sort of examples of like the use of big data, AI analytics to really try and almost look into the future based on the vast amounts of data available. Now, another area I can also think of where we haven't really looked into it that much from a dispute prevention point of view is also using natural language processing to analyze early communications. For example, when a customer first complains in an email to the business, or when parties raise, an unfriendly email about a forgotten invoice that wasn't paid. And now there's many different natural languaging processing tools that can be used. One example is sentiment analysis, just how sophisticated some of these NLP models and techniques have become to detect even slight changes in the tone of the email to a potential customer or employee. So a lot of these techniques, a lot of these tools are available in the market. And I think there's huge potential to use these new technologies in this particular field of dispute prevention.
That's really interesting, because I hadn't thought about what you said about the initial sort of assessing areas where there are more, I guess what I understood to be more likelihood of disputes. When you're saying with real estate or other sort of products, are doing an analysis to sort of look in this area, we see more disputes or types of disputes.
Yeah.
And then I guess what I had thought more about was what you just said about sort of when you get into the flow after the deal's done, how the parties are interacting with each other. And I think you're quite right that a lot of the times there's tension, but you don't quite tell that there's been this sort of subtle shift sometimes in the correspondence, and one side may not have even realized it. And if you had that sort of sentiment analysis, that would really raise a red flag that perhaps somebody wasn't paying attention to before.
Yeah, absolutely.
And is that being deployed? I mean, I love the name of your company, Deriskly, but are you guys deploying that today? Or
we are. Yeah, absolutely. So one of our solutions, which can be applied to different sectors, deploys sentiment analysis, among other AI models, to analyze email communications. Also, I mean, it's being used a lot in social media, to also analyze customer feedback, review websites. The point is to basically extract as much different types of data that could both internal, so email communications, and external. Angry customer, leaves a really bad review about, I don't know, say in the hotel sector, food poisoning at this particular hotel last Saturday night. It's to pull in all these different potential problems. You could say that it's like even going to customer support, but certainly our tool is able to flag more serious risks of legal claims. It's not just an unhappy customer with something that they don't like the color of the shirt they received. But of course, we know that even like where there's no legal claim, that it could easily, some sort of dissatisfaction, whether it's a customer or another stakeholder, could actually escalate into a dispute, even if there was no legal basis for the dispute. And that's going to it's just annoying for businesses. So our tool already deploys sentiment analysis. And before ChatGPT became all the rave, we actually also deployed other language models that was able to generate very tailored responses to solve that particular problem that's flagged. So if it's flagged by the customer, it would actually generate a sort of smart response, which can be edited by the human. So there's always human in the loop, that actually is in an empathetic tone, that is, just matches what the customer expects of someone who is of a customer service agent that is able to solve the problem. Of course, it does it in 2 seconds rather than, a customer service agent basically spending maybe 10, 15 minutes to respond to that particular email from the customer. So yeah, we have developed this tool and it's been sort of tested in different sectors at the moment. Where I see that a lot of potential is actually for the application domain expertise. So say in some sectors where, say, customer complaints are more regulated, and there's, like, for example, financial regulations. We've got a new project looking at how we deal with new financial regulations in the UK around consumer protection, and using our tool to be able to help financial services firms basically detect problems early on, prevent potential disputes with their customers, and through these smart replies and other sort of analytics tools that is really about also regulatory compliance. So yeah, so this is definitely, especially with generative AI, this is an area that is going to, I think, accelerate even more in its development.
Again, I hadn't really thought about sort of the mass of complaints for sort of certain industries that come in. I was sort of thinking sort of a party sort of dispute where you could be watching, on a construction project for
Yes.
person, where just sort of monitoring because in a construction project, for example, there's tons of correspondence going back and forth between subcontractors and contractors. But the way you've described it, the technology can actually, amalgamate all of these different things and sort of show where there's issues and then also provide responses. I mean, do you see a monumental shift with ChatGPT and other LLMs coming in to the fore, not only in terms of lawyers' use, but also commercial use? Is that going to get rid of in-house counsel and external counsel in the next 5-10 years?
It's a great question. Actually, when we started sort of showcasing our solution to in-house counsel, I think there were definitely fears that around job replacement. We figured out it's probably not the right team within a business to sell this solution to. But certainly, I think if we think about the role of an in-house counsel, it's really about mitigating risks. And I think there needs to be a shift in mindset, and that's happening now. And I think that moment was when ChatGPT kind of became a GPT. Generally, it's not just OpenAI's GPT. It's just this explosion in terms of use cases for the legal sector that everyone's now waking up. And not that they were asleep for the last few years, but certainly I think there was a lot of fears. I think the fears are still there, mainly because of, I guess, the significant risks that's posed by ChatGPT and similar tools. Not just around job replacement, but as we know, in terms of sharing confidentiality, confidential information, etc. Something that our company is really big on is really trying to ensure our solutions are very much puts data security and privacy at the forefront. But certainly from that perspective of an in-house counsel, having a tool like this can certainly help monitor, as you said, communications with a construction, within a construction project. There are new subsets of generative AI, such as like natural language generation that aids in communication, that is about clear and concise explanations and responses, something that I think sometimes the legal sector struggles with a bit, despite all this move to plain English. So a lot of the new generative AI models can assist parties, even in a sort of traditional, say a construction project, to effectively convey their positions, what they actually want to say, do it in a way that's not aggressive or hostile or ambiguous, so you can reduce misunderstanding. So it really is about facilitating constructive discussions to prevent disputes or facilitate their early resolution. So I think we really need to embrace the huge potential of these technologies to fundamentally improve how people communicate, which is really a big source of disputes.
No, I completely agree. It's usually the lack of communication or breakdown in communication, which really gives rise to a dispute, or at least sends it off to arbitration and mediation. I mean, is there, besides identifying it, are there ways you see tech can mitigate against it? Is it sort of in terms of early response time? Is that sort of
Yeah.
what the idea is?
Yeah, absolutely. I mean, instead of, we know how many emails we get a day. And if there is a high risk email in the background, we might not get to it. I mean, for me, I'm trying to clear my inbox, by respond to people within 3 days. And I think that's a pretty nice target. But what if those 3 days there is actually, I forgot to just check one email that has a high risk. And that's actually not flagged because obviously right now my inbox, there's no mechanism to kind of monitor emails that might contain a variety of risks from a disputes point of view. So it's that kind of being able to flag problematic email correspondence or complaints from a stakeholder in a construction project or customers. When you have, I don't know, thousands or millions of customers, that you're able to mitigate the risk of disputes. And now in some regulated sectors like financial services, you actually have to, there are targets for banks to respond to customer complaints within a certain amount of time. And banks don't really do well, as we all know, in that department. So there's a lot of, I think there's a lot of benefits in being able to respond quickly by particularly responding to the high risk communications and dealing with them first.
I was going to save questions to the end, but I think Sophie's got a good one here in the chat box. She's asked, is the AI trained in the tone of a customer complaint handling?
Yeah, absolutely. And that's one of the sort of exciting developments is that basically, the AI we've trained is able to match the tone of also that particular, you can train it to match a particular customer service agent or to match, well, I wouldn't say match a customer because if you have an angry customer, it's not going to obviously shout at the customer, but is able to actually have a tone that de-escalates that conflict with the customer by using the right words, the right tone in that automated smart reply. So it can do it much quicker than the best of customer service agents.
I feel like I've been exposed to a couple of these recently. I'm trying to remember what it was, but I'm almost convinced it was it was definitely a chat. But I'm sure I'm now thinking it was probably a bot because the customer service agent was so friendly.
Absolutely. Yeah, but these days chatbots are, because of generative AI, are actually for many businesses deploying GPT into their chatbots is actually a great step towards dispute prevention. We don't do chatbots, our company, but I think as you said, David, you probably used one of these chatbots that are now powered by GPT. And it's actually pretty good at maybe potentially resolving what you were complaining about or questions that you were asking.
There seemed to be this sort of, as Sophie's brought up, this sentiment analysis, almost like the AI or whatever technology they're using should be able to sense, are you making progress with the customer?
Yes.
Are you de-escalating it? And if you're not, does the technology have the ability to go to a plan B or plan C, or then maybe send it to a human?
Yeah, so our solution has actually, it's a great point. It has exactly that. So it has indications of how that correspondence is evolving, right?
Mm-hmm.
So if is it escalating? And then there's a little red line. Is it de-escalating? There's another green line going down. If it's saying the same, so it's still a very simple categorization. Is it escalating, de-escalating, or is remaining the same? But I think it just works for now. So that changes. That indicator is something that we've also trained our AI models to do.
In the theme of emerging technologies, is there any tech you see on the horizon or sort of advancements that you guys are paying attention to that you can share, you think will even change things more?
I mean, I think obviously we've kind of gone a really big leap with generative AI, and I think that's going to continue. GPT models are going to be more powerful. I think by the end of the year, we'll have something 10 times more powerful than ChatGPT. In terms of other areas of technology, I mean, I know certainly people are not talking about it as much, but I still think blockchain based smart contracts, something I've been working on for years, is still something we should still pay attention to. I know everyone right now is in the sort of AI hype, but as I've argued before, smart contracts have the potential to prevent disputes. It provides a more transparent system for executing, enforcing agreements, and creating just a more transparent and audible system for recording, verifying data, transactions, and really has the potential for parties to create a trustworthy, immutable record of events. And from that point of view, I think it's helpful in preventing disputes. But of course, there's the on-chain stuff and then the off-chain stuff, and of course the disputes in the real world can still happen even if you use a smart contract. But I still think there's a lot of attention there. We sort of stopped talking about blockchain and smart contracts the last few months, but I really just want to flag this as something that we should continue to watch.
I think integrating smart contracts in the blockchain with AI, you can almost see a world where you don't really need, a human hand to resolve a dispute or get ahead of a dispute. You can almost have them interacting together, and it would be a very sort of binary resolution. So I guess that's the future. Maybe that's where we'll lose a lot of our work.
Oh well, we should all get into this space then.
Well, I think we're slow on our way there. We're trying to keep up with you. Well, Mimi, thank you very much. Unless I'm missing anything else, maybe we'll turn to the issue of emerging technology when you're actually trying to resolve a dispute, and talk to Rob Bradshaw about what we're seeing today and what we can expect tomorrow. Rob?
Well, thanks very much, David, and thanks, Mimi. So Mimi's talked about how obviously prevention is better than cure, and so often what you'd ideally like to do as a client is prevent and de-escalate disputes before they get to the stage of arbitration. But we also know that unfortunately, or maybe fortunately for disputes lawyers who still depend on it for our livelihoods, some of those cases are going to end up in formal proceedings like arbitration. And so the next question becomes, what role can technology have in adjudicating those disputes? Now, obviously, technology can play a part at all stages of proceedings, but what I'd like to briefly discuss today is how they can assist counsel in the hearing room. And I should probably say, David, I'm not going to talk about virtual hearings or remote hearings, as I should probably call them. I think we've all learned a lot over the past few years about the pros and cons of virtual hearings. So I'm going to focus on a few concrete ways in which emerging technologies can affect the way that we present and test evidence at hearings. So
that sounds great. Any shift to sort of in person is always good with me.
Yeah, well, I mean, these technologies can be employed also in remote or hybrid hearings, but they're equally applicable in the physical context. And I think the first example that I'd like to talk about is that of augmented or virtual reality, particularly when it comes to presenting evidence in technically complex cases like construction disputes, which you mentioned earlier. So, I mean, when I'm talking about augmented reality, I'm talking about computer-generated images or text which are superimposed over the real world. So that could be using the viewfinder on your phone or an iPad or smart glasses like Google Glass or Apple Vision, as has recently been announced. Whereas virtual reality, we're talking about a situation where the entire surroundings are virtually generated and you navigate using a headset.
Okay.
And construction is a sector where augmented reality is, well, it's already being used within the sector, but in a way, lawyers have to catch up as usual. So it's already being used by architects, engineers, surveyors, both at the design stage and for inspections. So the programs on the market like Acula, like Gamma, augmented reality. And the idea is that you can use these to present 3D models. So you're no longer just showing off blueprints or concept drawings. You can actually, well, I'd say project, but more accurately, it's you superimpose the drawings, the models around a board table or even on a site visit. So instead of just going to a construction site and seeing the buildings half constructed, you can overlay what's called building information modeling, BIM, onto the construction site. So when you go there, you don't just see the scaffolding or the half constructed buildings. You might go there wearing smart glasses, you might go there using an iPad and see the blueprints, the concept drawings, the construction plans overlaid progressively on the scene in front of you. And of course, you can extend that to interior cabling, wiring, so visualizing the internal components when you can't actually open up the structures.
I was going to say, being able to conceptualize these, particularly in construction disputes, you can also see it in any sort of physical dispute for the tribunal or the adjudicator. It probably is a huge advantage, I think, in my mind.
Well, absolutely. And if you think if it's already being used by surveyors on site visits, then it's even more useful for arbitrators, for lawyers who aren't construction experts, because even for a non-expert, you can see how something should look according to the design and then how it does look, and immediately start seeing where things have gone wrong. And similarly with the internal components, you don't have to open everything up to start seeing where there's a mismatch.
Yeah, I've had a few disputes where the plant is already up and running, but you're talking about how it's constructed and the delay and the other additional cost. And as you just said, you can't open it up and have a look and see, what was going wrong previously. So I think that's, part of the, the fact development or inquisitive nature of disputes, that's really quite helpful. Do you see an application outside of construction? Because I think construction is the first place I always think of it, but have you seen it used other places?
So I think anything involving technically complex disputes. So if you take something involving a dispute over faulty machinery, for example, right, you can't necessarily open it up or give the tribunal a spanner and expect them to work it out by themselves. But you can take them through a blueprint. So you can take them through a 3D model where they're able to shrink themselves down to the size of the component, put themselves inside the machinery to understand how it fits all together. Or if you're looking at, for example, the investment arbitration context, if you take a case like Tethian in Pakistan, where at the quantum phase, there was this huge debate over the feasibility of the project, how close it was to power, to water supplies, and so on. I mean, if you're in the claimant's position in that case, it can be quite difficult to persuade the tribunal of the feasibility of the project. So on the adage that seeing is believing, helping the tribunal to visualize how that project would have looked once finished, because of course the project in Tethian never was actually constructed, never did get off the ground. I mean, that is potentially an advantage to a claimant. I mean, conversely, if you're on the respondent side, there was a case, I think 5 or so years ago involving Panama, which involved a project in a protected nature reserve or a very ecologically sensitive area, where Panama insisted that really to understand what the case was about, the tribunal had to undertake a site visit. So if you're in the respondent's perspective in that kind of case, you might want to be able to show the tribunal, look how, say, ecologically sensitive this area is, and look what the impact of a particular project would be. So I think ultimately it's a matter of perspective, but you can see how it already has applications potentially outside the construction sphere.
No, certainly. I remember when I was starting my career a few years ago, one of the arbitrators I was working for had to do a site visit in a very remote part of the world. The tribunal had to fly in by helicopter, and it was this huge logistical production. I think today they wouldn't do it. They would either, maybe they'd have an augmented reality or maybe a drone. But I guess the other question that rises to my mind here is, does this become sort of an issue of equality of arms? Because I could see how, one party having a very, deep treasure chest or war chest could make all these wonderful augmented reality, 3D models, and the other side is working with cardboard. I don't know. I mean, is that a question have you seen tribunals sort of grapple with?
I mean, that's always an issue that's raised when we're talking about these kinds of technologies. But I think if anything, it's likely to be a leveler. Because on the one hand, you've got the cost of a conventional site visit where you have to fly maybe 3 arbitrators plus the tribunal secretary out to the other side of the world, drop them in by helicopter, as you say, plus 2 counsel teams, plus accommodation and so on. And on the other side, you've got a software license for one of these programs, which you can get for under $100 a month. And even if you chuck in the cost of a few iPads, a consultant to build the model and present it, you're still likely to come out as more cost effective than a conventional site visit. And I've not used augmented reality in my cases, but I have used drone footage. In fact, I've seen a case where both sides have put forward drone footage involving a project. And again, I'd say the cost is a fraction of what would be a conventional site visit. Plus, of course, there's the advantage that unlike a site visit, the tribunal can always go back, open up the model and explore it as much as they want during deliberations.
That's a very good point. I hadn't thought about that. And I was also wondering maybe you could even, portion out the cost to the parties and have sort of you always talk, there's always this idea of having an independent expert, right, that the tribunal has, but I've hardly ever seen it put into practice. I guess here, maybe you could have an independent expert do it on behalf of the tribunal, and then both sides could fund it, and that might sort of make it an equal playing field. But well, let me turn, because in the interest of time here, and thank you. I could talk to you about this for quite a while. Let's talk about lie detection technology, because I actually find that, I wouldn't say more interesting, but sort of more interesting.
It's definitely more of an emerging technology.
So have you seen it deployed? What have you read about lie detection and sort of sentiment analysis, I guess, when it comes to witnesses?
So it's a good question. There's one area of arbitration where actually lie detectors, as we know them, have actually been employed. Obviously, there are many commercial cases that are potentially confidential that we don't know about, but we do know that it's been employed in several sports arbitration cases. And that's in the context of, I guess, not an emerging technology, but what we think of as the classic lie detector, the polygraph, which has been around for close to a century now. So that's obviously a machine that works by measuring blood pressure, heart rates, breathing, perspiration. And that's arisen in several sort of anti-doping cases before the Court of Arbitration for Sport. So the typical case is an athlete fails a drug test. They take a lie detector test voluntarily, swearing their innocence. They didn't take any performance-enhancing drugs, and that therefore the prohibited substance must have got into their system by another method. And then the athlete wants to rely on that negative lie detector result as evidence to strengthen their denials and their protestations of innocence. And what we've seen is actually after some initial skepticism at the beginning, tribunals have been willing in sports arbitration cases to admit that evidence onto the record. Now, what's interesting is that although they've generally held it to be admissible, they have found ways in practice to sort of, let's say, diminish its weight. So there haven't been any cases that I'm aware of, at least, where lie detector evidence has played a crucial, a decisive role. But I think what's interesting as we're talking about emerging technologies is how the same principles that we've seen applied to polygraph evidence might be applied to a new generation of lie detectors, which developers are working on at the moment.
Can I just, on that, so the polygraph was that done during the hearing, or is it done prior to a hearing or outside of a courtroom, and then it's entered as evidence? Whereas, let me stop there.
It's a good question. So the typical fact pattern that we've seen is where they've undergone the test prior to the hearing, that it's essentially an operator has come in, has conducted a lie detector test on them, and has then issued essentially an expert report saying, according to my analysis, I think there is an X% probability that so-and-so is telling the truth, essentially, or there were no indications of deception during the test. There have been some cases where the tribunal has said, well, the operator is not actually available for cross-examination. They've not put forward an expert report, so we're going to kick out the evidence on that basis. I think what's different with this, what we call the next generation lie detectors, is that they are convenient enough and portable enough that you could actually use them in the hearing. that you don't have to have someone strapped up to electrodes sitting in the chair under cross-examination. And the way that works is that these, although they still work on the same principle, so the idea that deception has a physiological reaction, so you can essentially measure someone's reaction and tell whether or not they're likely to be telling the truth. Instead of looking at, say, blood pressure, they look at so-called micro-expressions, so the fleeting involuntary movements on your face. They look at things like eye movements, pupil dilation, voice stress analysis, if your voice is breaking a bit under stress. And the idea is that actually these verbal cues can be picked up just using an ordinary webcam, the camera on your phone, an ordinary microphone. No need to hire a specialist operator. You can get apps on your phone which essentially promise to use the same technology. And rather than having an operator that you have to hire and who might have to give an expert report, many of these programs also promise to use machine learning. So you could, in principle, feed them a training data set of interviewees answering questions, whether truthfully or falsely, and then for the program to essentially learn from itself what kind of facial expressions or eye movements are linked to deceptive answers. And there's actually a couple of researchers who have been doing this at the University of Tel Aviv and the University of Maryland. So the idea is that the program could learn over time how to improve its own accuracy rate.
Yeah, as an advocate, I think having that ability in a hearing would be amazing. But I think there'd be a lot of ethical issues. I mean, with that, have you seen anybody really deploy anything like this during a hearing? And I guess B, what was the understanding that it is being deployed? Because I could see, having to tell the tribunal the other side that you're using this technology, or if someone found out you weren't, what sort of implications that could have. And I guess the other question is what are the implications? I mean, would you, as someone who's cross-examining someone, say, okay, I know this person's not telling the truth, I'm going to keep going on this line of inquiry? Or do you somehow tell the tribunal, clearly this person, the machine says this person's not telling the truth, you should disregard their answer?
Again, I think there's a lot of implications to unpack, both in terms of the integrity of the process and in terms of the rights of the witness. It's interesting, actually. There was a case, the Indian Supreme Court a few years ago, which relied on a technology, or which addressed the technology, functional MRI. So the idea that by tracking blood flows around the brain, you can essentially tell whether someone is telling the truth or lying. In which case the fMRI tests have been relied upon to secure a conviction for murder. Now, in that case, the Indian Supreme Court held that fMRI, like the polygraph, like other so-called lie detecting technologies, were an invasion of the witness's privilege against self-incrimination. Because the idea is the witness might say, no, I didn't do it, but their brain is involuntarily giving a different answer. And so the idea was that this was actually a violation of the witness's core rights. So that's something that a tribunal would potentially have to grapple with if they're asked to admit lie detector evidence. And you've already seen these technologies being used outside the arbitration context. Some police departments in the US, there have been trials in Europe at border control to detect whether or not a traveler is acting suspiciously or lying about the purpose of their visit, or by employers screening job applicants. And in fact, there's a case in Massachusetts at the moment, I think a class action case against a retail chain, which is accused of screening applicants without their consent during job interviews.
Oh.
Now, as to how is this addressed in the hearing, has this been used in practice? Part of the difficulty is, well, how do you know? Because if one side applies to put in evidence saying, "Oh, actually, we'd like to interview or to cross-examine this witness under the use of this technology," that's one thing. That's something the tribunal can decide upon and weigh up these concerns. But there is a danger that you could, for example, feed the video feed from a cross-examination to one of these apps. I mean, it's increasingly common even in in-person hearings to record the hearing or to live stream it, have a hybrid setup for the benefit of remote participants. And in that situation, it's kind of difficult to know and to police if one side is perhaps feeding the very same video feed to one of these applications. Perhaps having a little red light flash up whenever the witness shows signs of stress or deception, if their voice breaks, if they look away, if their pupils dilate. And that potentially could give a hint to counsel to push harder or to press the witness on a point. So I agree that would be hard to police. It's something tribunals may, in a few years' time, even have to consider it in POs.
I said, in an odd way, it excites me, and in another way, it terrifies me. So, I guess what side of the dispute I'm on. But in that same regard, do you see a technology, for the benefit of counsel being applied at fact checking, in real time, or being able to make sure or help the counsel or even the party sort of come to grips with what can usually be a very complex set of facts?
Absolutely. Mimi's mentioned already language processing, and there are forms of legal tech already on the market that employ a type of, let's say, fact checking, but although in the context of citation checking, legal briefs. We're talking about programs such as Quick Check, Brief Analyzer, mainly designed for US litigation. So they work on the one hand to automatically cite check your brief. So taking perhaps one of the routine mundane tasks away and seeing whether you've missed relevant authorities. But then they can also go further and essentially check an opponent's brief to see if they're misquoting or taking out of context any authorities, and if there are any authorities running against their position. So the next step would then be to apply that potentially to witness testimony, and instead of applying, let's say, a citation check, a fact check. So whether or not a witness's answers are consistent to other evidence on the record and to flag contradictions. Now, what's interesting is that actually fact-checking technology is again in development and has been trialed outside the legal system in politics, essentially. So in a trial which ended in 2021, PolitiFact, I'm sure aware of them, developed a program called Squash. And the idea was that you could play out a video of a politician giving a speech or participating in a debate, and that using automatic speech recognition, it could transcribe what the politician was saying, and then compare that to a database run by PolitiFact or other fact-checking organizations to rate the politician's statement as true or false. So it could display an instantaneous real-time fact check during a speech or debate. And that was actually tested during the State of the Union address in 2020 and the Democratic primaries. And what's interesting is that the general conclusion was that it was, let's say, a mixed success. So in principle, it worked, but it suffered from transcription errors that could result in some quite amusing inaccuracies. And that also there was a shortage of previously fact-checked database claims. Now, I think those kinds of challenges, actually arbitration could be well equipped to overcome. So in terms of transcription errors, hearings are often run with real-time transcripts. Even if you have automated speech recognition in the first degree, you still have court reporters there. So I think the transcription inaccuracies are something which actually arbitration is well placed to overcome. In terms of the actual process of fact checking, we've seen how far, for example, large language models have come recently and are still progressing. So the ability to say check a statement given by a witness in cross-examination and compare that, for example, to the information that the witness gave in their witness statement or other evidence which is on the record, I think we're not too far away from. So it could even be as simple as if the witness mentions a particular email, a particular letter or meeting in their oral evidence, that the ability to immediately find the relevant piece of evidence on the record and direct the counsel to the relevant exhibit number, for example. That is already a large part of what cross-examination is about, to try and tease out these contradictions. And obviously it's easier for a program to memorize the record than it is for an associate.
Well, maybe not for a good associate, but I think one of the issues both you've talked about and Mimi's touched on is, I think the tech is evolving or emerging, is what we're saying here, very quickly. And it's hard, I think, for the legal field, the everyday sort of, legal practitioner to keep up. And then also to integrate it into our practice. And I guess the thing I'm thinking a lot about, and ArbTech's been thinking about, is, what is going to be that turning point where, we start incorporating the tech that is the cutting edge tech into your practice, into the hearings, into pre-dispute resolution, or pre-dispute identification. And I guess the question I've had and sort of mulling about more broadly is, what is going to be the catalyst for the legal profession to get on board faster, or what has been the catalyst with prior technologies? I don't know if either one of you, I mean, I think clients, or users, of the legal services insisting or talking about that to the lawyers will get them to pay attention faster. But do either one of you see something as being a catalyst besides, us discussing it or it being applied more readily by courts or arbitral tribunals?
I'm happy to just have my 2 cents first. I guess we, as I've said, I think the last 6 months with, and I do think the leap in generative AI is truly a leap. I think if we're talking about a catalyst, the fact that we have now cases before suddenly the US courts where judges are thinking of sanctioning lawyers that are using ChatGPT to write legal briefs is quite a turning point in many ways when you think about how radical that sort of news story was when we first learned about it. And of course, the risks associated with using this sort of technology without thinking about the consequences. So I think we, in many ways, when this technology has become mainstream and there are so many now use cases in the legal sector that we see generative AI is creating, I think there is a bit of a turning point here. As to other new technologies like virtual reality, like smart contracts, blockchain, I feel like with technology, there's there is a hype cycle as well, and so I never say I can predict into the future. I don't think I would have predicted the jump we've made over the last 6 months with ChatGPT. I can only imagine that there's going to be more leaps that we can't even foresee. But I think the times are changing, and I think I really agree with Sophie's point. Sophie's left a comment on the chat about actually it's also about really fundamentally thinking about what we do as lawyers, as people who supposedly resolve disputes. Could we shift our roles as actually preventers of disputes? That's the hard. It's the harder bit, which is changing the culture and the mindset. I like the way Sophie puts it. How do we free ourselves? It's really using technology as a tool for enablement. And so I think we have seen some turning points the last 6 months. I think there's going to be more to come. Of course, it's going to be very hard to change institutions and cultures overnight. And I think members of this community, ArbTech, are already way ahead of the profession. And I can only just encourage those of us in this community who really do believe in the potential of new technologies to be that enabler, to be that tool of liberation that will best serve not only our clients, but also the wider society. When we think about the use of technology in promoting access to justice, the power for good, tech for good is huge. And we obviously, as lawyers, the risk-averse side is also to help our clients, help society understand those risks. So we can play a really important role. We shouldn't be fearful that our jobs are going to go. We should see and really think about and act on new types of roles that will emerge and create those roles proactively in our profession. So yeah, I'll just end on that note.
Thank you. Maybe Rob, do you have a particular perspective on that?
Sure. So taking your question about what the catalyst would be, I mean, I think a lot of it is going to come down to the needs of the clients, and often that is associated with cost and convenience. So to take the augmented and virtual reality example, I think, when a client is weighing up, okay, we can either fly everybody out to the other side of the world to look at a construction site, or we can use this technology to bring the construction site into the hearing room. I mean, for an in-house counsel, the answer is going to be obvious. In terms of the other technologies that we've discussed, I think that's going to be far more difficult, because the idea of, well, first of all, cross-examination, lawyers like to consider it an art as much as a science, that it's considered something uniquely human and is in a way a test of the skills of the advocate. And of course, tribunals consider themselves as the ultimate judge of credibility. That the arbitrator is the lie detector. So I think having technologies, so I wouldn't say replace, but complement human advocacy in the hearing room, that is something which I think is probably going to be one of the last areas to shift. So only, I think, when technology has been adopted at other areas of proceedings, or is more common outside arbitration. So we see automated fact checkers being employed to combat disinformation, for example. We see, the real-time transcripts or the real-time fact check popping up during politicians' speeches. I think only then would lawyers, famously conservative, I think, be willing to introduce it more and more into the hearing room. In terms of, I think, Sophie's question about how might technology free up parties, I think one of the key things is, and this goes to what Mimi was talking about earlier, is this early intervention, is potentially an early case assessment. And that might take the form of predictive justice, in the form of, actually the algorithm giving you an opinion or a probability of success. But it could also be something far more simple, which is that, when lawyers come on board a case at the beginning, it often involves digesting a huge amount of information, a lot of upfront costs, front loading, and the ability, if you're able to give, for example, a database, a universe of documents to a large language model that is able to summarize, condense them down, and that allows you, the lawyers, to give a realistic opinion as to the merits of a case, for cheaper and for quicker at an early stage of the process, or that might encourage settlement. So I think even if it's not in the form of predictive justice, anything that sort of allows you to get a good idea of the merits of your case at the outset, I think that is something which is likely to free up parties from embarking down a long and potentially expensive road.
I agree completely. Is there, just in the interest of time, is there any, I see, Andre, thank you for your question. Is there any other questions the audience, I think, which is sort of wrapped up in what Mimi and Rob just talked about? Are there any other questions from the audience? I'm being mindful of our hour coming to a quick close here. No, well, I could probably talk about this for another couple hours, but in the interest of sticking to our time, I think we'll close out here. I want to thank Mimi and Rob very, very much on behalf of ArbTech and myself for putting together this really thoughtful presentation on emerging technologies and the two fields you both given a lot of thought to. We really greatly benefit from all your insights. So thank you for being with us today, and thank you to everyone else for joining us. And like I said, I think earlier, this will be posted onto the ArbTech website in due course. So if anybody would like to recommend this to their friends or colleagues to hear all the insightful things we've discussed, that would be great. So thank you very much again for everyone, and enjoy the rest of your day.
Bye.
Thank you very much.